Tuesday in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
And here we are, Justice Serve TV. Michel Bryant here. And look who's here. If it's no, that wouldn't work. I was going to say if it's Wednesday, it must be Bob Bianchi. But I think we did this on Thursday last time.
Yeah.
Yeah. Good to have you along, sir. Always a pleasure. Back by popular demand. People were making comments. And unlike with me, they were generally positive comments about you. So that was very nice to see. So thank you, sir, for joining. Linda's on assignment. What are you up to? What's been happening? What are you doing there?
Listen, Michael, I'm looking at these graphics. I'm like, I have jealousy, but the good kind. I'm happy for you guys. You got scales out there. You got the pictures. You got old school pictures, new school pictures. So I know that this show is so like edgy, cutting edge, and cool. I've decided to put my EMT gear on.
Look at that.
I'll be there for you. But no EMT gear would be perfect without the cap. So in the style of James Carvell or Elon Musk, depending on what side of the equation you may dalliance from, I am going to do the show as your EMT lawyer. How about that?
I like it. And
Yeah.
you know, I've heard from confident sources that you have Riz. Is that am I hearing that correctly?
Michael, can we go there? Do you want to go there or no?
Go ahead.
All right, so guys, listen. I'm an emergency medical technician, as you can tell. I started when I was like 17 years old. I did all the way through law school. I was just telling Michael the story until I became a baby assistant prosecutor. That's because eventually I became a big boy assistant prosecutor, and then I recertified last year after a 35-year hiatus. And now I'm writing for a place called the South Orange Rescue Squad, where I grew up and where I used to ride before. And this weekend, I was in my gear and I have my. Oh, if I had known you were going to bring it up, I brought the picture. I have my outfit, my uniform, my walkie-talkie, and my tummy's hurting. So, I mean, these are the realities. Like you look at Michel Bryant, or my Jersey girl, they're not always feeling great. They look pretty all the time, but they're not always feeling great. So I went to go get Rolaids in one of these like 7-Eleven-ish kind of places. And I get a bottle of water, I get Rolaids. I don't say a word to the young man who's about 19 years old at the counter, and he's checking me out. We're not exchanging any words. I'm not feeling too good. So that's a little unusual for me. And he just looks at me at one point as I get my receipt, and he goes, "You got unspoken Riz." And he said it with a smile on his face. So I don't know what that means. So I just said, "Thank you." And I walked out, and I went to a younger crew member, and I'm like, the guy in there, I know it's a Gen Z term, just said I have unspoken Riz. Is that a good thing? But she goes, "Oh, that's a big thing because it stands for charisma."
Mm-hmm.
So I have unspoken charisma. I'm not sure what the unspoken piece is, although we did not talk.
Well, you didn't speak, so
Yeah.
maybe if you had spoken, he would have said you just have Riz. But yeah, I thought that I saw that post. I thought that was so funny. I had to run to the old man's dictionary and see what Riz was. That's actually one of the few that seems to make sense.
Yeah.
It comes from a word that is flattering in the way that Riz is flattering. So anyway,
next time we come on, Michael, I'll also tell you we got into a big conversation. Your audience can wait. Some of them may know, some may not know what skibbity is. That's another one. Took me a little while. Riz was easy. Charisma.
Yeah.
Skibbity, much more sophisticated.
Yeah. Okay. It's next time. Yeah, I saw that. I heard you mention that word too, and I was hoping I would know because I'm so hip and cool. But no, I had absolutely no clue. So, look what we have here. I think we have some breaking news here. Hold on just a second. Let's see if we can find it. Sometimes the breaking news is easy to find. Sometimes it's not. I just don't know why. But
It's like Almond Joy has nuts.
Hey, well, I guess I don't know. Maybe it wasn't so breaking. I guess I can't find it. Oh wait, there it is. Is that it? No, it's not it. Stand by. It's so breaking. It's broken. I think is what it is. Let's see. Nope, not there. Nope. Okay. Well, like I said. Oh, wait a minute. I think I found the breaking news. Okay, so here's the breaking news. I was just watching. We weren't planning to get into this Brian Kohberger case, but Bob, I was just watching a hearing that they called an emergency hearing, and it was on. They use the YouTube channel there for the court, which is always painful. It's like a crazy Zoom. You have the judge about this big, and then little boxes. Anyway, here was the deal. They're having hearings tomorrow. They had a hearing earlier this week to determine of those hearings, which ones could be public and which ones were going to be private, because the judge is very concerned about, obviously, tainting the pool. As everybody knows, this case, and again, Brian Kohberger, of course, accused in killing those 4 co-eds in Moscow, Idaho. They've moved it now to Ada County, which is Boise, pretty big area, especially compared to where they were in Latah County. And so the judge is still very concerned about, tainting the jury pool. And so one of the hearings, this is the best I could glean from it because they're being very, quiet about it. It has to do with the genetic testing. They're going to have what we used to in California called the Kelly Fry test, and now Dobert. I still don't like the way it sounds. I think they call it a Frank hearing there in Idaho. So they're going to have a hearing about the genetic testing, because you'll recall, Bob, they found Brian Kohberger because of familial DNA.
Right.
Has become so popular and so effective in tracking people down. So what do you think about the judges weighing that? It's a very, difficult decision. What can be public? What can't be? It's no way to protect the public entirely from all of this information. What's your take?
I have a very easy take here, and normally I'm in the moderate view of things, is keep the courtrooms open. When the courtrooms start to go dark, so does information, so does government abuse. The courts were specifically meant to be open so that the public could, in fact, test its system of prosecutors and judges, and making sure that the greatest freedoms we have, and that's why it's in the Bill of Rights, are all of our right to a jury trial, right to proof beyond a reasonable doubt, that founding father understanding that abusive government can be used politically to twist and torture people, and let's keep it open and give all these constitutional protections. Now, that said, I understand that there's also a constitutional protection that the defendant has a fair trial, and that the case is proven against them beyond a reasonable doubt on competent evidence. When we're talking about jury selection, however, I've tried a lot of very high profile, very public murder trials, and so has Linda and many others that that are in this game. And the judges always find a way of getting a jury pool that can say that they can be fair and that they can evaluate the evidence in a fair manner. And even if they've heard about the case, it's not an automatic elimination and does not automatically mean that you should be removed. So if I had to weigh the balancing act that needs to go on here, unless it's something to me of a sensitive nature, like sexual assault or something of that nature that needs to be done to protect the confidentiality of witnesses or their privacy, that's a different story. But if it's merely because it's going to affect the ability to get a jury pool, one, I don't buy the argument. And two, even if that's true, that's the cost of a democracy. Take your time, and you'll have to take a little more time. That's the problem here, to do jury selection. And when I say it's a problem here, Michael, I'm sorry to go on a rant here. It's because I've been in jury selections. I've done jury selections, and you get these judges that are looking at their watch, like, you keep going like this. It's gonna be 3-day jury selection. It's gonna be 5-day jury. Well, you know what? To my judge friends out there who I love dearly, sometimes that's the way it be. And sometimes it's sticky when you're looking for justice, and it doesn't all fit in a nutshell. And stop looking at the clock and do things more qualitatively. End of rant.
Yeah, it grinds slowly for a reason. You want to get it right as best you can. The system's not perfect. We know no matter what the publicity might be, and I call the Kohberger case a Mars case, because unless you live on Mars, you know about it. You know the big picture. Yeah. You're going to have some thoughts about it. And the best you can do is try and ferret out the folks before they get in the box that are going to have a prejudice. Now, I say that we all want jurors with a prejudice. We just want prejudice for our client, whether it be the prosecution or the defense. And we know people are going to lie, and people are going to try to get on juries. And it's so tough to weed through that, but that's the process. That's what you got to do. So if it takes a little longer, boo-hoo. That's the way it goes. So This judge, he was also asking about, he was concerned that some of the pretrial hearings, typical motions in limine, he was concerned that they would be talking about material that might not make it into the trial because, well, so what?
Yeah, I mean, no, exactly, Michael. So what? You make look, again, the public has a right to understand what the pretrial motions are. Now, you indicate there's a Daubert motion that's going to be going on with regard to the admissibility, the scientific reliability of the DNA evidence. That's what a Daubert hearing is always about. And there's a number of factors that the judge will look at. There's no doubt in my mind that they will pass the Daubert factors with regard to its admissibility. Interesting point, because I know a lot of your viewers here are trial aficionados and maybe law students or lawyers that want to learn about trial laws. Just because a judge says that it's admissible doesn't mean you can't argue the weight and credibility of the expert opinion that's being given. The only way expert testimony is going to be ruled out under Daubert if it's declared scientifically unreliable. Like a polygraph exam is a scientifically unreliable instrument. It's not going to happen with DNA. DNA has passed the Daubert standard and the Fry standard. That's the old standard, and the Frank standard. They've passed over and over again. These are pro forma motions that are filed by the defense in every case. And so as a judge, in terms of jury selection, listening to having out there motions, well, to your point, many times during a trial, information comes out and judge, objection. That was inappropriate evidence outside the bounds, the goal lines of what the evidence rules allow. And what does the judge do, Michael? He says, ladies and gentlemen of the jury, you will disregard the information you just heard. That information was inappropriate to come out. You will not consider in your deliberations. Now, you will ask the question, and there's a whole jury judge. How can I take something out of my mind? And the judge explains how you do it. Same thing here with pretrial motions. I don't see it. I don't understand why this is even an argument, to be honest with you.
Yeah, and I know to drill down a little bit on the DNA, my understanding is that he's thinking there will be some relatives revealed that are far removed from anything Brian Kohberger did or did not do, and he doesn't want them identified, and they're actually going to be using initials for those people.
Fair. Okay, you just took the word. It's normal. You took it right out of my mouth. That is I love that. That is a fair consideration. Okay, because that's a privacy interest that we talked about before. But there's also a remedy to it, and that's the initials, as you've indicated. So there's less restrictive things that can be done rather than shutting the courtroom doors down.
Yeah, so it'll be interesting to see how this plays out. This is this new judge's first test at dealing with this very, very high profile case. So I guess we're into jury selection on this show today, because we've got these two new trials just starting with jury selection. Nobody's been impaneled yet in either the ASAP Rocky case out of LA, in which he's accused of shooting at but not hitting his friend, except for the knuckles. And then, of course, the Jacqulyn Johnson case. She's the former prosecutor in the Ahmaud Arbery matter, accused of misconduct, kind of given a pass to Gregory McMichael and Travis McMichael, those who were ultimately convicted of killing Ahmaud Arbery. So let's start with ASAP Rocky, because I know how, because somebody with Riz like you, I know you're thinking Rihanna, you're thinking ASAP Rocky, you're in the mix there. So here's what's going on out there, and there are some interesting players. Joe Tacopina, I'm sure, from various events. Is he from Jersey or New York? He's from New York. He's New York. He actually said at some point during the jury selection that he wants to condition people to the way he talks, because he talks, kind of like, hey, like a New Yorker, he's like that. I'm from California. We're not allowed to have any accent, but he is, so he's talking to California jurors in LA, and he, was kind of out front about, I want to make sure you don't hold that against me.
Yeah, apparently he had the jury laughing, actually.
Yeah, I'm sure he did. And Joe's good.
I don't want to, just a real quick, jump in there. When I was reading that, what he was saying to the jurors about his New York accent, this is important, Michael. This is important. The only thing that matters is those jurors. It's the only thing that matters. And if they like you and you resonate with them, especially from the beginning, if I were the prosecutor, I would have been jumping up, or I would have went to sidebar, because I don't want to sound nasty in front of the jury, and say, Judge, I want this panel struck. I want this panel struck based on that, because he is trying to ingratiate himself with them. It's completely inappropriate. I need to set a tone with a guy like Tacopina that your nonsense is not going to play here.
Well, I wonder how the judge is going to handle that. The judge has been very interesting in the case. I saw a hearing the other day that his name is Judge Mark Arnold. We'll get into some of the details of the comments he made today, because he's borderline inappropriate himself. So in this day and age, so they are working their way through the mix. I mentioned the other night, I think Monday. Yeah, Monday, Linda and I were talking about it because it was on the eve of the jury selection process. And I said that in California, we used to do what we call the 6-pack, where you'd put 12 in the box and then 6 chairs right in front of that. And you would work on those 18 people and whittle away and then bring in others to replace. This judge does only the 12 and works his way through those 12. So there's no idea how many they actually have qualified, but they brought in, let me see some of the numbers here. I think they brought in about 200. and they're asking the normal questions about do you know Rihanna? Do you think whatever you hear in this case about ASAP Rocky, true or false, is going to affect her? And if so, will that affect your decision? Very interesting, collateral issue in this case to have a big star, and he's a star, but she's a star, to have that a consideration for the jury. Have you ever had to deal with something like that?
Not with the level of stardom that we're talking about, but with the level of notoriety and its impact on people. Yes. And what I mean by that is that, there are times that people are going to have a great level of sympathy or potential emotional volatility with regard to one side or the other based on who they are, their status or their fame or their celebrity. And it's been really fascinating to me to watch, to say, for example, in this particular case, with the fact that he's connected to Rihanna affect you, how many people will honestly say, yes, it will?
You're right. It gets back to my point about people having to be honest about it. And, that jury selection process is not a comfortable process, for the prospective jurors, because they're being asked to be open and honest about stuff in a room full of folks they don't know, right? So this one lady said, until you mention that, that there might be some impact on Rihanna from what happens in this jury, she said, I never really thought about it, but now that you mentioned it, I guess it would affect her. Yes, we'd like to thank and excuse this prospective juror. So, good questioning. That's, that's something that somebody might subconsciously not even think about till they got to deliberations, right?
You know what I found that some judges do? It's important how the judge is approaching these jurors, because the jurors understand that the prosecutor and the defense lawyer are adversaries, and they have a position and a side. The judge is the only person the jurors look to that is a neutral personality to them, and is the person that's got the robes on, sits higher than everybody else, and makes rulings when the two sides are arguing with one another. So the judge carries a lot of weight. What I've seen, Michael, in some instances is when that juror, like you just mentioned, says, yes, now you think about it, with Rihanna, that could affect my judgment. I've seen judges do things like this, or I hate prosecutors, or I hate defense lawyers. Are you saying to me that if I told you that you must only guide your decision based on the facts and law in this case, that you would refuse to follow my instructions and be fair and impartial? And you see this like deer in the headlights kind of, oh no, Judge, I could do that. Mr. Bianchi, this juror is acceptable. And you're like, come on. Now you got to use a peremptory challenge on
exactly. You got to burn one, because this person is, they're going to be a follower, and probably not in a good way.
Right.
So I mentioned the Judge Arnold. They've been concerned from the beginning about whether Rihanna is actually going to show up at the trial, for obvious reasons, because it would be kind of a spectacle. She doesn't expect to, but the judge said, let me know if she does. So instead, today is his mom, Rocky, and of course his real name is Mr. Mayers, but his mom and his sister show up, and they're sitting there in the courtroom, and the judge is asking, really, just who are these people, And he's told who they are, and he says, let me get the quote here. He says, Renee Black is the mom, and he says, what were you, 7 when you had him? This is what he says to A$AP Rocky's mom, who's sitting there. He's not done yet. You're very beautiful, the judge told her. That's on the record.
Wow.
Yeah, so I thought that was a little bit interesting.
That's like, I see, that's like, with judges, you kind of, it's like a wine. That's got the smell of the 1978 to 1985 judge. Like, that's a comments that they would be made in the 70s and 80s. Ooh,
yeah.
Wow.
Interesting, right? And so just for the numbers, just so everybody knows, they aren't wondering, she was 26 when she had him. He's 36 now. So what is that math? That 52 or 62?
62, I would think.
Yeah, 62.
I wonder what he would say about me. I wonder if he'd catch it. I got the Riz.
Well, he would probably sense that. There's no doubt he would sense that. Okay, so let's see, what else did the judge do? They let's talk about the plea deal. That I want to get your take on this. You're a former prosecutor. You involved in these shenanigans all the time. Yeah. So on the eve of trial, and there was a reference to this on Monday, the judge even said, "Hey, I think there's a chance of settlement," which is, I think, a weird term to use in a criminal context, but that's all right. A chance of, not resolving this. And Tacopina basically says, well, my client has no interest in that. Obviously, if I'm given some information, if a plea comes my way, I'm obligated to share that. Clear Tacopina said he wasn't looking. So comes along the plea, okay? 7 years suspended, 180 in custody, and I think 3 or 5 years probation after that, okay? Now, he's up for possible 24 years based on the 2 assault charges, okay? Assault with a deadly weapon. I think there's a gun enhancement. So you're presented with that. You get, for your dude, you got 6 months and then, a little bit of monitoring over time or the possibility of 24 years. That sounds like a tough decision to make.
Yeah, I mean, I heard it actually with the parole eligibility guidelines too. It may be even less than 6 months. So I love that we have this little factoid, and it always used to bother me when we used to work collectively at another location that we would never find out.
Law and crime? Would that be law and crime?
Oh, okay, yeah.
Oh, yeah, we talk about it all the time. We use their video quite often. So
yeah, when we were working at Law and Crime, I used to always say to the producers, "What's the plea offer in the case?" Because some of it didn't make any sense to me as to why I was being tried unless there wasn't a plea offer. And then I know the producers, they really weren't getting it, like the importance of it. But it illustrates why. So as a trial lawyer or as a prosecutor, even when I'm thinking like, what will the defense want to do here? I understand that the idea of a perfect agreement is where both people hold their nose and they walk away. Okay, so let's use that so I'm going to give you something and you're going to give me something. Now, a lot of this depends on the strength of the prosecutor's proofs, the ability to prove the case to 12 beyond a reasonable doubt, and the other issues. The prosecutors have the uphill battle, as it should be, because that's what the Constitution tells us. For the defense side, you were sitting there and you're saying to your client, look, if you get convicted, here's the realistic sentencing parameters. Now, just because they say 24 years in prison doesn't mean you're going to.
That's the headline. That's the headline.
Yeah. So, I mean, we always get that, right? So is there mandatory minimum? Is there a period of parole now? I can tell you, like, for example, in New Jersey, if you get nabbed in any kind of gun case, any whatsoever, and you're convicted, you've got an automatic 85% between 5 and 10 years. So let's say it's at the minimum 5 years, 85% before you're even eligible for parole. And that's just for having the weapon. That has nothing to do with shooting and an aggravated assault, which would be consec. So I may be going to a client saying, look, they're offering you 180 days, but here's the thing. And I don't know the state in particular, but at least in Jersey, before you can plead guilty, and in most places, you have to give a sworn factual basis under oath as to what it is that makes you guilty. It's not a NOLO plea, right? You have to tell the judge truthfully what makes you guilty. And if you have a client that says to you, I didn't do this, I'm innocent. For example, in this case, as I understand, the defense is that the quote unquote, what they believe to be the weapon was a starter pistol.
Yeah.
And it was therefore does not meet the definition of a firearm under the law. Now, if the jury, if your client says, if the prosecutor said, look, I'll give you 1 day, or I'll give you 1 day of probation and no jail time if you plead guilty, and the client says, but I didn't do this, you can't take the deal. You are forced to go to trial and run the risk. So I don't know what the story is, whether he says it could be one of two things. I didn't do it, so I can't give the factual basis. That's track one. Or track two, I did it and I don't care because they can't prove the case beyond the reasonable doubt. Either way, you're rolling the dice, because when I used to counsel clients, or do counsel clients on some hardened cases where, I had a guy with a murder and attempted murder, aggravated assault on a corrections officer, stabbing him in the chest with a pencil, a couple of drug cases, and they went from 20 years to 10 to 7 to 5 to 3 years in state prison. And I said to the guy, I don't jam pleas down people's throats, Michael, but I said to the guy, you don't want to take the 3? Well, look, I'm going to go home and have a bowl of pasta and spaghetti and meatballs one way or the other. You may be spending the rest of your life eating bologna sandwiches. That's your decision. And ultimately, he took the deal. It was the smart decision to make.
Yeah. And, those deals, I don't know if you remember the Sarah Boone case. She's the woman who left her boyfriend in the suitcase, ultimately died, right? She was convicted. We were down there to cover that. She was offered, I think it was, I want to say, 5 years. I mean, it was deal, compared, because life in prison was on the table. Guess what she got? Guilty and life in prison.
But I don't know. I guess as I get older, and even the prosecutor in me, which is what my career is mostly, been known for, It's what we call the trial tax. But I wonder how justice is sometimes. You know what I mean? It's like I worked for a judge that used to be really good when I was a young hotshot trial lawyer as a prosecutor, and I was all full of vim and vigor. A guy rejected a plea on an armed robbery case, and it was close to a probationary, so it was a little state prison time, and then a short period of probation, and then he got convicted. And the judge gave him 15 years. And I want the judge to give him 20 years with 10 years of parole eligibility because he went to trial. I look back on that now and I'm like, Bob, it was great that you had that gung-ho spirit and whatever. But was it fair that you were willing to offer the guy this over here? And just because he went to trial and got convicted, then hit a fly with a sledgehammer? And I look back on my career and I'm glad that I had a judge that had more reason than I did.
Interesting to look back at those decisions and kind of reflect on those with your current Riz. That's a factor. So and on the California situation with a plea, they can do a plea not unlike the YSL defendants did in Atlanta, where there was a NOLO on a number of the charges. There was some guilt, but no explanation, no story about why they felt they were guilty.
Yeah, we need to drill down a little bit more. And the other thing I like about Jersey, I don't know if California is the same way, is that before the trial starts, the judge, or before the trial gets set, the judge has a trial order. I can't imagine this isn't done in other states. And in the trial order, it lists all the issues, the motions, the in limine motions, and what the plea offer was. And the judge will be very specific. And you do this as a matter of constitutional protection for the prosecution. Actually, it benefits the prosecutor to say, you do realize that this is what you're facing, and this was the plea offer. Well, I am not trying to tell you what to do or not do. I want you to know by rejecting this plea that the plea will be withdrawn, and you will be at trial now facing these penalties. I wish we knew more of those things, Michael.
Yeah. It helps everybody in the decision-making process, right? So one other thing in this case with Tacopina, he decided to bring a Sixth Amendment motion based on what he believed was an inappropriate jury pool that didn't properly reflect the defendant's race. So the numbers suggest 9% of the folks in the area from which the pool was drawn were African American. 9%, obviously. ASAP Rocky, African American. Only 5% of those in the collected pool were African American. So I'm sure, without getting my magic 8-ball, I'm sure you can tell me what the judge decided on that issue.
No, it doesn't. It
denied.
Yeah,
denied. Yeah, and Tacopina.
It's the process has to be such that it's eliminating a juror. Those statistics mean nothing unless you can argue the process.
Yeah, I mean, you could end up very possibly with 12 white people on this jury, and it would be perfectly legal. That's a possibility.
Isn't that the funny thing, though, when you listen to these things and when you listen to challenges, our peremptory challenges that we get to use, where you get a certain number just to knock somebody off for no reason, and you have what they call Gilmore issues, which is named after a Supreme Court decision where they said, well, you can't knock anybody off for race or whatever. So the irony of this is we want to be a colorblind, society, and I understand. I mean, so. But yet, unless there's not enough of one race, then we become uncolorblind. Then we take the colorblind off, and we say, no, you need to do more things that make it more, equitable. That's what some would argue. Others would argue that it's just unfair to say that a group of people within the community with a process that's been fair and randomized cannot judge the guilt or innocence of somebody simply because they have a different race. I don't know. Interesting.
No, I think you're right. By trying to make it safer and minimize it, you're actually focusing on it.
You're creating it. Yep.
So I get it completely. I agree with you. Let's see what else, if Joe did anything here. They're hoping to have a jury. I thought they might even have one by today. We haven't been really given some great detail about how many have been impaneled. I was curious too about how many peremptories they were given, because that's, the statute requires a certain number, but the judge can always, change that depending on the circumstances, sometimes multiple defendants, other issues like that. Only one defendant in this case, though. Let's see, what else? Anything else in this case that I found interesting at this point? Let's see. No, I guess that's about it. I think the most interesting thing in this case is people would look at it, I think, and say, what happened? And we know it was about two former friends. Altercation occurred. This was November of 2021. And allegedly, the defendant fired his semi-automatic pistol 3 or 4 times and somehow grazed the knuckles of ASAP Relli, his former friend. That's the case. I wonder how many people will look at this case and say, "That's it. You got this trial. This is it. These are the assaults." What do you think about the level of, I'm not trying to minimize the violence, but what do you think about the level compared to many other cases that are out there or going to trial?
Well, you're talking to a former homicide prosecutor, so the
Yeah,
level of violence.
like Knuckles. Come on.
Excuse me, because those knuckles is serious and permanent injury for the rest of his life. I mean, but look, I mean, each state has its different predilections. For example, in New Jersey, probably the most restrictive gun state in the United States. I think it very well could be. I'm not being hyperbolic, although I'm prone to that tendency, but I'm not with respect to that particular issue. So, the mere possession of a firearm without even having used it unlawfully against another person, the mere possession of the thing is a 3 to 5 year sentence with 85% of parole ineligibility. I'm sorry, 5 to 10 years with 85% of potential parole ineligibility. So the prosecutors would look at it like the mere fact that you're possessing a weapon and you're bringing it out in public and you haven't followed the law with regard to carry permits, so on and so forth, as a serious offense. That's how they'd see it. I could hear prosecutors saying this. I could hear them saying, well, these entertainers and rap figures and people out there, whatever, which, I don't know if it's true or not, that are out there carrying weapons pose a significant risk. It's not just about him. It's about other people and other people who have been killed and shot and killed. That's endemic in the industry.
And so we want to send a message, there's a little bit of the Fonny factor, I would call it here, where, there's a target because they think maybe some of these folks, if 1 or 2 acts occur, that everybody's doing it because that's part of the reputation, the street cred, all these things that they do. And we want to control that. So I'm not trying to minimize, hey, if the guy had a gun and he fired it in public, he's lucky that nothing worse happened.
Yeah. And keep in mind, they're offering him a 6-month sentence.
Yeah. So what does that tell you when the prosecution says we'll give you 6 months? Does that mean their case is not that strong?
It could mean that. And it could mean that I have had a lot of problems with prosecutors, especially publicly elected prosecutor. I was appointed by the governor, so it's a little bit of a different. I think that's a cleaner scenario. But I feel that the prosecutor in this case was not grandstanding for TV and career potential, because they didn't offer a deal that had to be refused, right? So a lot of times these stars are offered things that they have to refuse because you're not getting that worse if you get convicted at trial. And the prosecutors are trying to squeeze out a little bit more time, publicity, fame, and fundraising opportunities. Here, the prosecutor offered something that is a legitimate thing to consider and could have very well successfully resolved the case. Again, how strong the proofs are, the evidence are, I don't know. A bullet is a bullet. I mean, that's usually pretty not too difficult to prove. There was a round fired and that it was fired and that this guy supposedly, had a weapon. I guess they don't have it with them. So he can make the argument that, I had what you saw. I'm assuming somebody saw, I don't know the facts, but I'm assuming somebody saw something because he's having to argue that it was a starter pistol and he only uses it as a threat of constructive force, but it really wasn't capable of fire. Well, the jury will have to make a conclusion. There's no direct evidence, but this is what we always talk about with circumstantial evidence. Round fired. Was there an argument? Was there a motive? Who had what looked like a gun? This may not be a hard case for prosecutors to prove. I just don't know yet.
Yeah, and there are some photos, but they're kind of disjointed. It's not like a full scene. It's the alleged perp in a hoodie. Can't really recognize him. Has a gun of some sort that's also not recognizable. A lot of issues, I think, for the prosecution. But we'll see how it plays out. Oh, I know what I want to ask you about.
Michael,
this.
I'm sorry. Let me just say one thing for your audience to round this out. There's also another factor with this too, and a lot of times with high-profile people that we represent, the mere conviction itself can be a life sentence for a person, right? So their career, their reputation, the collateral consequences, the penalties that go along with that, the things you forfeit as a felon, those things are not easy either for people that have a lot of money, fame, popularity, and success. That could be a play too. Sometimes my high-level clients don't do what may be the more prudent legal course because of those reputational issues.
Okay, so here's another factor that may have nothing to do with it. I don't know. If you're going to do 6 months, probably that would begin almost immediately. He's been named some sort of honorary judge or something at the gala that's coming up, the Met Gala. That's going to be in May. and then he's got a big movie coming out with Denzel Washington. So both of those those would have occurred within the 6 months. I don't know if that's a factor or not, but he would have been otherwise occupied and couldn't handle those duties.
Well, who knows? Who knows how many more of those? Who knows if those opportunities don't evaporate with a conviction, and who knows if future opportunities? Look what happened with just the mere allegations of impropriety with Johnny Depp. I mean, these things have serious repercussions on their future. So I believe there's more of that at play than the time.
Yeah, and again, if he didn't do it, he's going to fight about it. So here's the one thing I wanted to ask you, because they added a new member to the prosecution team, John Lewin. Now, you and I were both at Law and Crime when the Durst case played out in traumatic. I don't know how many months it was. Was it like a 3-month trial, something like that? And so, yeah, he's the guy. Now, here's what I found interesting, and we watched the hearing when he made his first appearance. He's officially he's second chair officially. And folks, I think, know that means he's not the lead attorney. He's the assistant attorney, basically. He's there, fill in maybe on certain witnesses. But do you anticipate John Lewin being a second chair in terms of the way he acts in court, the way he participates with various witnesses? I don't see it.
Do you remember the quote of Maya Angelou that it's not what you say, it's not what you do, it's how you make me feel, or make me feel?
Yeah.
I think John Lewin is the person I'm thinking about during the Robert Durst. He was the lead prosecutor.
Oh yeah. He had Durst. I think he did 4 days.
I remember being on set and anchoring and throwing out, which I've never done before. And please, I know this sounds so obnoxious, but he was so obnoxious that I felt I'll go one notch below him. I threw out a lifeline that if he wanted to learn, I don't care how many years you've been there, how to properly prosecute a case, I'm always available by phone. Okay. You need to calm down. I mean, that was one of the, I could be completely wrong, but I felt that was one of the, I was surprised that he got a case like Durst. I was like, is that the best the office has to give?
Well, and remember, he was involved in the interrogation when they arrested him. He was in the room.
Yeah, I mean, I've been in the room too. I mean, I don't have a problem with that, but I just think that his whole prosecutorial modality, his dripping sarcasm, arrogance, refusal to let people answer questions, bombast. I don't know what other shitty words I could say. Excuse me, for those of you out there. The fact that another prosecutorial agency actually thought of all the prosecutors that we have witnessed that are unbelievable that you could get assistance from. Number one, I ran the prosecutor's office. I would never, ever, I would have to hang up my prosecutor. This is my EMT hat. Let's see, it said prosecutor on it. I'd have to hang that bad boy up. If I had to go to an outside source, and I didn't have the talent in my own agency, or I myself was not talented enough to get a conviction on a case like this, you're not talking about sophisticated science or any need for that. So I would completely demoralize my staff by doing something like that. Oh my gosh. Just that mere fact that you're telling me or tells me already this prosecution's amateur hour.
Well, we'll see how he does in this particular case where, this weird thing happened at the hearing the other day. Tell me if you've had this experience. The judge, of course, is saying, look, one witness, one attorney. I don't want, whack-a-mole attorneys popping up and down dealing with a given witness. Normal. That's very normal. Mm-hmm. Lewin decides, well, what if I am examining the witness and then during the cross-examination, co-counsel does the objecting?
Right.
Yeah. So he won't object to the witnesses he is examining when they're on cross-examination. And they'll do it that way. He's identified. So it won't be two of us, Judge. It'll be just the other guy. That's weird.
It is weird, but not shocking. I think I'm going to start a new phrase in the law. We're going to call it the Lewin. Making an issue out of something that there's not one. It's the Lewin. Okay. I mean, this is what I'm saying. You'll wear a judge down eventually. That will never inure to you. If you remember, there was a lot of tension between him and the judge in the Durst case. And eventually a judge is going to snap back with something like that because they got to maintain control of that courtroom again. This is, I'm not going to lie to you. Michael, I'm in shock to hear this. I'm in shock that another prosecutorial agency actually watched the Durst trial and said, That's the kind of
That's
guy
our guy.
I need here.
Well, look what happened. And this is somewhat related, but the Karen Reed case, the prosecutor Lally in that case, who obviously had some issues since the result was what it was. Well, he's still on the case, but now he's second chair, and they hired an outside counsel to come in. So he has to sit there as the guy who lost the first time. I mean, it was a loss. Hung jury's a loss. And he's got to sit there and suck it up with the new guy that's been brought in. I mean, that's weird too.
Are these people living in the real world? I mean, if that ever happened to me, which it hasn't, or I was the boss, I would never have the guy who fell apart, whose case fell apart, who was abjectly terrible, who caused all the problems and should have known the issues that would develop during that case. You can't. That's not even fair to do to the new guy that comes in, because putting the old guy in as the second seat, there's going to be animosity there. There's emotions going on there. You don't need to saddle the case with any more of that junk. Get it the hell out. Get a new guy in and start from the beginning.
That's what I just thought. For everybody's sake, why is this guy still sitting there? Okay, so this will be an interesting trial as it unfolds. You got Joe Tacopina, not a shrinking violet, and then you got John Lewin. It's going to be fun. I'm looking forward.
That aspect is true. It will be Gladiator-esque like.
Yes, it will be. Okay, so let's move on to Georgia. And Jacqulyn Johnson, she, of course, the former DA when the Ahmaud Arbery case unfolded. That was, I was trying to think of it was February. Yeah, February. No, it was September. I'm trying to remember. Can you help me? I can't remember. I think it was February in 20. Oh, yeah, that's right. Then the indictment was not till September of 21. Her indictment. So what happens is, by way of background, she gets a call an hour after Greg McMichael is questioned at the scene by the cops, the body cam we've looked at. An hour after that, he calls her and says, "Hey, got a problem. Been involved in a shooting. I need some advice." So she, within a reasonable period of time, steps away because Greg McMichael was an investigator in her office, in the DA's office. So she steps away, but she recommends another gentleman who also probably should not have gotten involved, because it comes to light later that he decided that Travis McMichael, the son, the actual shooter, should not be arrested. Okay. So the real question and the charges against her in this case are violation of her oath, because she apparently played favorites with Gregory McMichael, her former employee, and told two officers, the secondary charge, which is a misdemeanor, told two officers not to arrest Travis McMichael, the actual shooter. So that's the nature of the case. It's going on with jury selection now in that little dot of a town. I was down there for a long crime to cover the Ahmaud Arbery verdict. Beautiful little town, little seaside community, but not a lot of bodies there in Glenn County, right? So they brought in 200 people, and they're working on getting through them. They don't think they'll have a jury till Friday at the earliest. So what do you think about this kind of case where you have the overriding case, Ahmaud Arbery, worldwide attention, outrage, joy when these guys were convicted, not just for state prosecution, but also on the federal level for 1983 civil rights violations. So they got it thrown at them, right? All three of them. I forget William Roddy. I remember that guy just got sucked in. He was the guy that followed and videotaped or recorded on his phone. I always felt that should have been severed out, and I'm not quite sure how that didn't happen. But man,
and by the way, he's the one who gave the police the videotape.
Yeah, and they were proud of it. Hey, I got it. It's right here. Here's what it is. I just think I would have been fighting tooth and nail to get that guy severed, because talk about guilt by association. Holy cow. So anyway, so that's the kind of case we're talking about. It's a monster. And now you have coming along the DA who arguably helped these monsters avoid justice for at least a little while. Thoughts?
I don't remember all the dirty details, but I do have the sensibility that once again, and I guess I'm going to be prosecutor bashing today, and I'm a big supporter of prosecutors, and I think that which actually makes me more critical when I see some of them doing the things that they're doing, a la Mike Nifong, the Duke Lacrosse case, or Marilyn Mosby in Baltimore went on her publicity tour, or Fannie Willis in some regards, or people running for office saying they're going to prosecute people as the basis of their campaign. When I'm seeing things like this, it's making my heart break from a prosecutorial standpoint, because I believe so much in the integrity of what it was we were doing, and so much in the respectability of our office to be fair and independent and impartial, and not, fear or favor. And I know those lines right now are like punchlines. Our institutions have been so beaten up, but I took that so when I told my staff that a free cup of coffee will be an entrance out of the office as an employee and a potential charge of official misconduct, I meant it. I set a tone for them about what was acceptable, not acceptable. And I know the pressure as the head prosecutor when somebody calls you up on the phone and says, "Hey, can I just ask with the minute those boom, I'm already in front of that conversation. I'm sorry, I don't know what you're about to say. I mean, no disrespect. We've been friends for a long time. I can't count how many times, Michael, I did that. I understand the pressure, but you need to say, at the end of the day, people will respect you because you draw that line, even if they're trying to get something and they're not happy about it. Because you got two ways, for all of you who are out there, two ways if you're a government official to walk out of your office when your term is done. With your head held high that you did the right thing, or your head held low having done the wrong thing. You're going to be attacked no matter what you do, good or bad, high or low. You're going to be attacked. So do the right thing and leave with your head held high. I felt during this case that her entertaining conversations, her proximity to individuals that were making decisions that ultimately led to these charges not being filed was problematic. But whether or not that rises to the level of an act of what we would call here in Jersey official misconduct or abuse of your office, I don't know all the facts, so I want to keep my powder dry with that. But I want to say that when prosecutors are given an extraordinary level of discretion, extraordinary powers, my powers were not supervisable by anybody. They were in a black box. It was really kind of like really wild. So when you have that level of discretion, that makes proving a case beyond a reasonable doubt for abuse of that discretion not so easy. But I don't know what their evidence is. They may have some.
We know the allegations. We the evidence will play out as it plays out. Imagine this though: you were a prosecutor, now you're a defendant. In
defense
high
lawyer.
profile. No, I mean you're a defendant. I'm putting you in her seat.
Okay, yeah.
She's the prosecutor, and now she's she hasn't been in court in quite some time. Now she's back, but she's sitting at the other table. Can you imagine?
Well, I got to say, if she did something that's wrong, then she put herself in that position. If she didn't do something that's wrong, then that's a very unfortunate thing. So again, we don't know the facts, but if this new prosecution is based on going after a prosecutor for political reasons and not because of evidential reasons, then that is a gross injustice. I can only imagine. I had a lot of discretion calls that I made, and we were in a political game. I mean, there's politics involved with this stuff, and some people are playing politics today a little too hard. Okay, and you used to call it bare knuckle. I don't mind bare knuckle so long as you don't got like you don't have something
brass
in
knuckles
your hand.
with it.
Yeah, brass knuckles with it, exactly. And unfortunately, we're getting more and more to a place where I'm seeing that new administrations come in and just literally obliterate whatever the previous foe did, whether it was good or bad, because the game is about cruelty now, not about justice. I don't know. We'll see.
So this jury pool. Just to give you a sense of this area, they sent out 500 jury notices. They got 216 people showed up. So there were that many that either were dead, old rolls, I'm sure they got them off the voter rolls, or they had excuses even before they got to court. Anyway, so they start with the 200, right? The judges whacked away a number of them. He took 15 right off the bat because they were questioned and said that they had already formed an opinion on the case and that was not going to change. Now, some people will say that just to get off a jury,
right?
Just to get out of jury duty. I always share the story I had when we were doing the jury questionnaires and we'd gotten past those. They made it to this pile, and the people were sitting in the stands there, and we're going through the questions, and I'm flipping through this page 4, page 5 of quite the jury form in California, and the last note says, "I am a Nazi." Now I don't know how we missed that, but when we discovered it, we thanked and excused the Nazi. So some people don't. I mean, maybe he was, maybe he wasn't. but pretty sure he wasn't getting on a jury.
You know what? It's funny though. You never know. Like, I wonder about some guy like that because a lot of people can be like really like as a defense lawyer or whatever, a lawyer or judicial person. I don't want, but you never know what kind of like attitude. There's a group of people that are so anti-government. And so like they want to tear the government down, that somebody like that could actually be somebody as a juror that would never trust the prosecution. You just
that's
why
probably
you get rid
true.
of them. Yeah.
Yeah, and of course, if we hadn't gotten rid of them, the other side would have. So
Yeah.
let's see what else did they find in this pile of humanity here. They had 40 that they excused because in their written answers to their questionnaire, nobody said they were a Nazi, but they did say that they had biases that it would be very hard for them to ignore, and the time on the jury would cause them some major inconvenience. We used to say that to get off the jury, a slam dunk is if you have your own business where you have to shut the doors if you're going on jury duty, or if you have prepaid vacation plans.
Right.
In our system in California, those were two that were pretty solid get out of jail free cards. Anything in Jersey that was an automatic?
Well, we used to do the. Can you answer the following question? The pork that goes on a roll with egg, is it pork roll or Taylor ham? If they said pork roll, they got thrown off the jury almost. So it's the same with you, except for that other question.
Okay. All right. I don't know what the hell you're talking about.
It's a Jerseyism. There's a
It
big
must
battle
be
in North Jersey and South Jersey, so whether it's called the pork roll sandwich or a Taylor ham and egg sandwich. But no, seriously, no, that would be it. Prepaid vacations and detriment to the business. Yeah, same here.
Okay. So let's see who else we had on here that got bounced. Here's one that got bounced because she said that, quote, the defendant, former DA, interfered with the investigation and let convicted murderers, plural, go free. So that person was thanked and excused. Also, one that said that she had given the assailants special treatment. That was the quote. So bounced for that purpose. There was actually somebody, I found this one interesting, that dismissed a woman who said that she had pretty much decided that Johnson should be acquitted.
Yeah.
Yeah.
I think that what you're demonstrating here is when I was a young assistant prosecutor, I remember I used to hang out in this place that used to serve non-soft drink beverages, and people used to drink them copiously back in the day. And I had a crew of people that would always say to me, all you prosecutors want to do is convict innocent people and make a name for yourself. And so the minute they heard I was a prosecutor, or somebody heard I was a prosecutor, there was usually a snappy retort of something of that nature, which could not have been anything further from the truth. The greatest powers I've seen as a prosecutor, I've had as a prosecutor, were to rehabilitate people and not prosecute them. So but I get it. They had a reaction. I then became a defense lawyer, and those very same people, in all candor and earnestness, would say to me, now you're going to be a defense lawyer and let all those guilty people get out and make our society less safe. And when I would present to them the contradiction that they seem to have a problem, they were identifying with one side or the other, and they just switched. It was one of those things where they couldn't look in the mirror until later and say, you were right. I never even thought of that. And I suppose that this would be the thing that would, I'm not sure if it would embolden me to, I'm trying to answer your question before, if I were the former prosecutor sitting in that chair, if I'd be emboldened by this thought process or not. There are going to be some people that are going to make their minds up based solely on what her job is and their perception of what they believe that job to be. So that kind of gets me a little bit nervous, and I hope the evidence is really solid, because I'd hate to see somebody get convicted based on perceptions.
Yeah, that's what I think is going to be key. It has to be pretty hardcore. It's not going to have to be the appearance of some impropriety. It's going to have to be pretty darn solid.
I think that's going to be hard, Michael. That's hard.
I can't wait to see how it plays out. Those that have were also excused for saying this was a witch hunt and that she was just doing her job. So it sounds like it's been cutting both ways. Those that feel that, again, these are all prospective jurors that have been dismissed. So we're not sure who's getting on the panel, but they think that's going to take at least a few more days. They actually took today off because of the weather. They're freaking out down there because that lower snow belt, has dropped down. I've got friends who are in the Atlanta area, and we got 3/4 of an inch. Yeah. And I'm like, Oh, shocking. The problem is they don't have the facilities, for the, either plowing or they just throw some sand on the road and, hopefully it'll be okay. So they took today off, didn't bring the jury in. And this is, again, Brunswick, very tiny town, coastal town, probably even fewer municipal services to take care of the roads if they have any snow. So they've got 2 days now. The judge wants to get this thing impaneled and off to the races next week. So
Perfect.
So, sir, that's all I got for you. I know. I was going to kid you and say we're going to do a telethon now because we are I don't know, like 50 or so subscribers from 4,000. So I was going to threaten that we would stay on until we got to 4,000. But
man, come on. How many you got now?
I think let's see. I don't know what the actual number is right now. I have to look at another computer here.
Don't you guys get any questions during this show?
I'm not very good at putting them up there when they happen because I'm talking. Sometimes Missy, who is one of our mods, will put them up there. To be honest, I haven't even really looked at them. I'm just looking at them.
Yeah. I
saw a note that suggested that in I think Jason Hodges had noticed something about the ASAP Rocky case where there's some question about the evidence of the bullets themselves or casing or any evidence of how many shots were fired. So that's obviously going to be a pretty important bit of that story. Hey, see that? Brooklyn just noted something. Bob, if ASAP was your client, would you have taken the plea? And we kind of talked about that.
First of all, I like that question because, like I said, just to reiterate and add some stuff, when we analyze these cases, many times we don't know what the plea offer is, and it's so important because I wondered many times, like, why is this going to trial? Only 4 or 5% of the cases genuinely go to trial because it can't be resolved. So would I take the plea? Let me start also philosophically explaining that when I talk to a client, I tell them that just so you know, I am not the kind of lawyer that's going to beat a plea down your throat. Me and my team are all former prosecutors. We're serious level trial attorneys, experienced and tested. My job is to do the best job I can for you before the trial to get you the best plea offer possible. Usually the prosecutors respect who we are, but most importantly, they know we're not afraid to go to the dance. That's a very important fact. So I'm giving you guys some real inside baseball here. When I was the prosecutor, a lot of people wondered how the decisions got made. And sometimes there'd be what I used to refer. Michael, can we keep going? Or no?
Oh, yeah.
Some people.
It's the beauty of having this whole thing under control. We do it goes longer or short. And to answer your question, we're 56 shy of 4,000. So.
All right, so let's come on. Let's get this next 56. Get your friends, get your family members, smash some of these buttons down here while I'm giving an explanation of how the plea bargaining system works. You're hearing it here. I'm going to give you information that defense lawyers don't know, that they always wondered. And where I was at was to say that there used to be a term I called kitty boo-boo. Kitty boo-boo. And a lot of defense lawyers would say, Bianchi likes the other lawyer. I had a case and they were offering 10 years and then they went to another lawyer. Okay, they went to another lawyer and now they're offering probation. And Bianchi likes that guy and not me. No, what I would do is I would bring them into the office. And I used to love doing this. It was like one of the best parts of my job. And I would take the file that when they had it, and then I take the file with the new lawyer that picked up the case that got the better deal. And I'd say, now, I know this doesn't mean everything, but let's start with this. You see how thin your file is? Let's open it up. You put a notice of appearance in. You basically let us know that you represent the client. Now, look at the second lawyer's file. He's got motions for suppression, motions to disqualify the statement that was taken from the defendant. He got an expert's report about this, that, or the other, or the forensic evidence. He got a polygraph exam where his client passed and says he didn't do it. He's got an investigative report here. And you know what? Our team looked at it, and I hate to do this. I hate it because here comes the kitty boo-boo. We know this guy will try a case and you won't. Mm-hmm. Okay. Mm-hmm. And because I don't fear you like I'm a martial arts guy. I've done martial arts my whole life. So if I'm gonna spar somebody and I see that they're not moving in a certain way and they got their hands in their pocket, well, I'm not worried about being aggressive and moving forward because I know I'm not going to get hit. But if I see somebody that's in front of me that is throwing and knows how to do it, I'm going to be more reticent because I don't want to get hit. There's no difference between a fight on the street and a fight in a courtroom, other than one's mental and the other one's physical. Okay. So that's one. I'm saying all that because all these facts get taken into consideration. The prosecutors will offer better pleas to the better prepared lawyers. That's the dynamic. Now, on the other side of that, you have a client who's got collateral consequences. A plea of guilty to somebody like this is going to be much more significant than an ordinary person where it won't affect their job, their career, their future, or their prospects. Here, I think it will have a significant impact. So the mere pleading guilty alone is going to be a major thing. Then there's time. Of course, there's jail time associated with it. So what I would sit there is I would debrief the client and I'd say, here's the evidence in the case. Here's what we can anticipate they're going to bring forward. Here's my experience and my training. Here's where we're going to cross-examine. Here are the evidence rules that are at play, because believe it, I've won more cases because I knew the evidence rules better than my adversary did. They're both in court sometimes. I'm watching on court TV that I do now. And you have both sides and you're like, oh my God, who's making the objection? This is a significant piece of evidence. If you stop it from being admitted, they'll lose their case and nobody's making the objection. Yeah. You got to know your evidence rules. So all these things come into play. And then I make a recommendation to the client, but I will never tell the client. They ask me, what would I do? I usually put it in terms like this. If this were my family, given all of these multiple things, and we're dealing with a human institution with emotions and things of that nature, I'd be inclined to recommend that you take the plea. Or I want to take a chance and go to trial, but I have to let you know, if you get convicted, you're going to be going to state prison for a long time. But the choice is yours. So I know it's not a satisfying answer to you as to what I would say. I don't know the quality of this evidence. And I don't know all those factors that I just discussed. I don't know how good the prosecutor is, although, yeah,
well, you know a little something.
I know a little something. And so the defense is doing the same thing. Is this prosecutor any good?
Of course.
Are they good on their feet?
Of
course.
Mean,
when I was a county prosecutor, when I was the head guy, I had like 45 assistant prosecutors underneath me. There were 3 that I had complete confidence I could give any case to, and would not only go in there with pride and passion and capability and would bring it home. They were winners. I mean, in the sense that they were good, solid trial attorneys. And the others, I'm not saying they weren't, bad. They were bad, but they weren't somebody I give the high level case to. Listen carefully. Listen what happened in this case. The head prosecutor or whoever made a decision to bring a pitch hitter in before the case even started. So maybe as a defense lawyer, if I'm Tacopina in this particular case, I'm looking at that. It's like, And then if I'm Tacopina, I'm doing a deep dive on Lewin or whatever his name is. Lewin from what's his face?
Yeah, it makes you wonder. And you mentioned it before. Not only they bringing in a pinch hitter, but that's the guy.
That's the guy.
That's the guy.
I may be. Look, I love a guy like him because he's like super. Like he's like you poke this guy and he's this is like all this frenetic energy, and I'm just poking this guy the whole trial. So I'm not just trying the case. For the jury, I'm trying him too. And Tacopina's that kind of guy.
Oh yeah, I could see that. Yeah, that's why I'm anxious to watch this thing unfold. And you're so right about, most of the stuff I do now is against the government, and they hate going to trial. They hate it. I love it. I don't do all this prep work just to be sitting around. I mean, in court, whether it's the judge or the jury, that's an audience. Give me an audience. That's what I want. I don't want to just posture and then cave in.
We've moved in 30 years from where I would be trying a murder case and the jury would be deliberating and I'd be doing an opening statement in another courtroom, and the pace was unrelenting and very driving, to a place now where if you have the temerity, that's how I put it, they look at you having the temerity to try a case and exercise your constitutional right as a defense lawyer as if you are are you causing a problem? I mean, I got literally called into one of the worst experiences I've ever had in my career as a trial defense lawyer. Was out of 15 people arrested on a RICO drug case, all of them pulled out plea forms without looking at any of the evidence and pled their clients guilty. And I had, again, the temerity to say, I'd like to review the discovery before I make a recommendation as to the plea offer. I got dragged into the chambers by the judge, beaten up in chambers, said, I want to go on the record. You want to go on the record? Fine. Got limb blasted on the record. It was a bad experience. I was upset. In the end analysis, I proved that my client didn't do what was said, and the case was dismissed against him. And I could have made a big mistake if I caved and I buckled because it wasn't a pleasant experience. It's a long and short of it is we've become, Michael, instead of, in my opinion, skilled trial practitioners, not that we're not that, but we become more criminal claims adjusters.
Mm-hmm.
They just want to move the beans from one jar into another jar. The truth and justice be damned. Sorry, that's Bob Bianchi's opinion. And I'll stick by it any day of the week. Anybody could sit there with their veneer and the bar associations and say, oh, that's a very critical thing that you said. It's the truth.
It is the truth. Yeah. And I think anybody who thinks that it's not is either not in the game or they're just kidding themselves because they want to feel better about themselves.
Yeah.
And now, and it's easier in that sense to be an attorney these days because you don't have to be as good. You really don't. You don't have to be as good.
No. Yeah. I mean, but you're 1,000% correct. I was trying cases against icons. And when you try a case, this is not a place for the weak of heart. You're in front of a jury. You got to know how to move evidence, and you got to know your evidence rules. You got to know how to make an objection. Look, it's called the adversarial system. I do a lot of training on mindset. You've probably seen my LinkedIn newsletters on mindset. I'm going to be giving a 3-part series with the Bar Association called The Warrior Spirit. And why am I doing that? I'm doing it because I've been lecturing for years to attorneys. You need to get past what I had, and I didn't have Google, and I didn't have all these things. And honestly, back then, you're not to have fear. Be a man. Men don't have fear. I was scared to death to try cases, and I'll be the first guy to admit I never thought it would have been that way. I was starting to develop a panic disorder, whatever, but I got past it. I got through it. It wasn't easy, but I made a conscious decision from that point forward that I would never let another lawyer suffer in fear and almost lose their dream and their career because they had nowhere to turn. So I started this thing about the warrior spirit. And Michael, this is the biggest thing that I see lacking. The lawyers don't have the confidence. They don't have the skill set. They've never had. Look, sometimes you just got to. You know who gave me my first trial? Mike Corbanics. You know Mikey.
Sure.
Mike Corbanics saw me in the hallway and said, hey, you ever try a case? I'm like, no. He said, here you go. He handed me a file. It was a jury down the hallway. And there I was picking a jury.
I was
scared to death.
Yeah.
Like, we're not doing that anymore with our young lawyers.
Yeah. And don't even talk about the civil arena where you can't get a courtroom, you can't get a trial, and everybody's settling.
Yes.
Very frustrating. That was one of the reasons I left the big firm. Because I got sick of preparing for the dance and then never getting to get out there on the floor. It's just very frustrating.
Yeah, you don't have enough judges. You have in civil, I used to say, really, it's just an exercise in how many trees we're going to kill in paperwork and motion practice. The last civil case I had, Michael, it was all I would say was like an 8 defendant case. So there's a lot of people. I get it, and I would sit in the very back of the judges. They'd always call you in. It's always the pre-courtroom jury judge chambers conversation, and I would sit in the back purposefully. I believe in everything that goes on in the courtroom needs to be planned. Where you're sitting, what you're posturing, what you're doing, and the judge would go around and say, "What do you think?" It was the same thing. Once a month, they drag you in. Is it like a torture? It's like the drip thing, and hopefully people will just like weekend. By the way, I saw a nice, beautiful spotted dog going past you. Was that a Dalmatian? Did I see?
Oh yeah. He gets annoyed when I don't let him in.
Oh yeah, he's kind of So and then finally, like she get to me. She goes, "I know, Mr. Bianchi, you just want me to pick a jury." And I would say, "Judge, can we just get a jury?" When you pick that jury, trust me, at that point in time, people come to they see we always used to say it, the whites of the eyeballs of the jury. All of a sudden, deals happen then.
Yep, that's true. That's true, and sometimes that's good. It's just very frustrating for those who want to get in there and mix it up. Rightfully, not just to have some fun, but you got a cause, you want to present your case, and the opportunities to do that are not what they used to be. It's unfortunate.
Yeah.
Well, we're going to mix it up with a few of these cases, and let's see. Oh, we lost 4 subscribers. No, just kidding. Just kidding. I have to update that. I'll hit the refresh. 4,000 is that's in this game. It's a toe in the water, but we're relatively young. We're working to try and grow this thing. Here's
the thing I asked Michael. Like, this is like a really. I'm not trying to pat you on the back or blow wind up your skirts. You and Linda. Between the media experience you guys have and the trial lawyer experience you have and the personalities you have, sometimes you wonder. There are so many podcasts that are out there. I mean, even I'm sure the guests you bring in, hopefully myself included. Like this is the place to be. This is real. both from a media perspective and from a legal analyzing scenario, and I think entertainment. I think both of you guys are extremely entertaining.
We've always felt that way. You know, this is infotainment. You know, it doesn't have to be boring. It can be educational. It can be fun. So yeah, I appreciate that, Bob.
So Brooklyn likes
we're
great
working on
show. But Brooklyn and the rest of you guys out there, I'll say what Michael love Bob Bianchi's opinion. Unspoken Riz, yes,
Yeah.
yeah. You're right, unspoken Riz. Yeah, but you know what, you guys, Brooklyn, Missy, get out there and tell your friends. Michael didn't know I was going to say this. I had no intention on saying this, but this is the problem, right? You don't want to be a minor voice in a whole world of clanging going on out there, and it's only through community support. And I'm the worst guy at that. I do that myself. I never ask anybody like to support me because I kind of think it's like, well, if they want to, they will. But I do it for you guys because I really think you guys deserve it. And you guys got the graphics down, man.
Yeah, that's thanks to Dizzy and Missy. They've done all of this stuff. So you see Domino there at the door. See Domino? That's Domino.
Is that my best friend is named Domino?
Nah, it's also a stripper's name, but that's a different story.
Yeah, well, yeah, okay. Domino was wearing a sweater too.
Yeah, yeah. We have like there's
all these comments are popping.
He's got the plaid blanket on. He's got the plaid blanket in the spot. So here we go. Yeah. Goofball. Come here. Hop up. Say hi to everybody. There you go.
What a cutie.
There, see? Yeah, he makes a few cameos.
Domino.
We did a little podathon for the animals in the LA fires last week. Okay.
Beautiful.
Yes, I know.
So how many, Michael, right now, people are popping up, like comments are coming up. That wasn't happening during the show.
Well, that's because Missy is doing that. I'm not, I'm not multitasking that way. I try to kind of have my conversation going here. And sometimes if Linda is here, she'll do more of that than I will. And so I kind of not in the habit of doing it. And so, yeah, there's let's see, I don't see any total numbers, but there are a substantial number of comments and items on here. So
when we were at Law and Crime Network, guys, there was a time, Michael, I don't know if you were doing it, but we were on this weird program, a computer program. And from my laptop, people's comments would come in and I could see them. And I would respond back to them. I would like give them answers to questions. And we built up this really cool community. It really developed into something big. And then they stopped it, which I, for the life of me, could never understand. It wasn't like it was costing anybody any money or anything like that. But I don't know.
Yeah. So we try to do that. And certainly part of what we do, and we have members as well. And we go back through and respond to questions and comments, and every about once a month we do a comments show where we highlight folks who have good things to say, bad things to say, interesting things to say. So it's all part of the mix. What's very different from everything I've done for the last 4 decades in TV is the interaction like that. Before you'd show up at the studio, you do your thing, and it's a very private process. You don't really interact with anybody on the other side of the screen. So this is a whole different animal, and learning how to do that with YouTube and other algorithms that control your destiny. It's different. It's definitely different.
Fred is asking here, what the size of the jury pool wound up being? What ended up being the jury pool size selection in Jackie's case?
Yeah, they sent out 500, 216 showed up. And so they're whittling away at that.
By the way, I don't know why I said Miss Schmidt. Isn't that really weird? It's K. Schmidt.
It is K. Schmidt, yes.
So why did I say Ms.?
I don't know.
And am I allowed to say that? I'm not even sure.
Because you're a sexist? Is that it?
Oh, my God.
I
said somebody was a nice girl on a TV show. I got excoriated for 6 months. I had hundreds of thousands of hate tweets.
Well, you're no Judge Arnold. Is that the guy's name?
No, but I told Linda about this, our own Linda Kenney Baden, because like we always call her Jersey girl. She calls me Jersey boy.
Yep.
And I'm like, oh my God, I get it. I didn't mean anything pejorative about it. I've never been accused of being a sexist, but I said somebody was a nice girl, and I got all beaten up. I couldn't sleep for a night or two. I'm like, I can't believe this is happening.
I know. I tell jokes about it, but it's you can't compliment somebody's clothes or anything anymore if they're of the opposite sex. Maybe you can't even of the same sex.
I'm not sure you're even allowed to say opposite sex.
Could be. Let me get on our HR department right now. Hold on. Yeah.
You could say it to me. I mean, the other day, I was in some place that I didn't expect it in Tennessee, believe it or not. And I was in one of those places. Somebody asked me to eat eat something and you want meat, sweet, medium, or hot, and I like spicy food. I'm
Me
like, give me
too.
the hot, and I my face almost exploded. And I go to the bathroom, I got tears coming out of my eyes, and I'm looking, and there's like 4 doors, and they all have different symbols on them. And it took me like between the heat, I couldn't figure out what was what, so I don't know.
Did you pick the right door?
I don't know. There was nobody in there, so I
Well,
presume
usually you can tell because if there ain't no place to stand, you're in the wrong place, unless it was a one-holer. Sometimes
yeah. It had a bunch of just toilets, so I could have been in a ladies. what used to be commonly referred to as a ladies' room in the past.
Yes. That's a whole different road to go down. So maybe next time.
Okay.
Bob, always a pleasure, buddy. And I appreciate what you have to bring to the mix. Good luck with all the EMT stuff, and keep that Riz going.
All right. Well, I'll be on duty tomorrow from 4 a.m. to 6 p.m. So any of you are in my area and jurisdiction, I'll be there for you.
Okay. I'm going to do my best not to get shot. That's my plan. Okay. Take care, bud.
Thanks for having me on.
You bet. All right. That's going to wrap things up. I think we're taking tomorrow off. Maybe a couple little things that happened I may be forced to come on and comment about and drag Linda. But we're definitely going to get together Friday, bring you up to speed on what has been happening, and hopefully 2 cases that will have juries at that point. So have yourself a great evening. And as I like to say, till next time, try to